Yes.
Yeah, just listening to the talk, it's almost everything we've talked about is, or you talked about is your administrative duties, as opposed to judging things. And I just kind of like, are the judges, the justices just overburdened with administrative stuff? Do you have enough? I mean, it sounds like, for me, I'd rather you be spending your time judging cases.
Thank you. You're absolutely right. The administrative side in year 11-12 has been larger than life. I think it's probably unprecedented in terms of the issues facing the administrative side. And I hope that in 12-13 and the years to come, especially with the new administrative director, that we'll be able to shift those concerns to the administrative director so I can oversee it instead of being elbow into it. But I want to say about the judicial side, and that is, if not for the judicial side, I wouldn't do the administrative side. It is the price for the prize. The administrative side is the price. The prize is being able to do the cases. Because I've never worked with 6 more thoughtful people. So thoughtful, objective, and honest. And by honest, I mean, they tell you when you think you're wrong. And they not only tell you why they think you're wrong, they explain it and they tell you why and write it out. So we exchange a lot of written memorandum because we're all working on different things at different times. So half of my adjustment this year has been coming into the Supreme Court as the new kid on the block who happens to be chief. It's a strange environment. But I'm working with professionals, people who've been there decades on that court. And so they are extremely gracious and generous in their time, in their instruction. And when we argue on issues, we are all equal. The chief comes in, and I have administrative duties on that court, but I am really just one other vote on that court. I think the greatest responsibility I have on that court that's most interesting to me is I do assignment of cases. I assign the cases after petition for review is granted. So that's a very interesting prospect, one I've never had to do before. But another thing I'll say about the Supreme Court, it's gratifying at the Supreme Court because the briefing is so well done. Not particularly the parties' briefs, but when amicus write in. I only mean that in the sense that the parties are advocates. So you get one side from the petitioner, one side from the respondent. Your world is not complete. In comes an amicus brief. Oh, now I see the universe. That's what I mean by the amicus briefs. And you know, when I was at the Court of Appeal, I didn't get a lot of amicus briefs. But amicus come in, and it's very helpful for us to see the universe in making a decision. Because as you know, we work with a scalpel in a very narrow area. We really try to, because we don't want to disrupt the development of the law. So it's fascinating, and I'm happy to talk about that part in terms of how petitions for review are granted and what happens to them once they come through. So let me just say, once a decision is made at the Court of Appeal, that case then has an opportunity to come to the Supreme Court. So first, from the Superior Court, you almost as a matter of right, in most cases, except limited civil and some other matters, as a matter of right, you get to the Court of Appeal. You get that as criminal, you get it as a matter of right, and civil, you get that as well. So courts of appeal review all cases. They don't have the opportunity to deny review, except in writ petitions. So at the Court of Appeal, you hear everything, basically, that could be appealed from the Superior Court. But in order to get from the Court of Appeal to the Supreme Court, you don't get there as a matter of right, unless it's a death penalty case. So putting that aside, and putting aside extraordinary writs, what we have are petitions for review. So the loser, typically, in the Court of Appeal, will petition for review for the Supreme Court, literally asking the Supreme Court to hear the case from the Court of Appeal. And the parties will submit their petition for review, and the respondent from the appellate court, the winning party, will say this, why not, why it shouldn't be granted review. So every Wednesday, the Supreme Court meets. All 7 of us meet in my chamber, and we all have the stacks of petitions for review. Now they come into the Supreme Court, and if it's civil, it goes to civil central staff. If it's a criminal case, it goes to criminal central staff. And those are groups of attorneys, and they triage the case. They write a short memo. They say, this case was decided at the trial court, this was the result at the trial court, this was what happened at the Court of Appeal, this is what the Court of Appeal did, this is the issue that the parties want review granted, here are the facts, here's a brief discussion, submit, they'll recommend whether we deny, grant, review. So all of us come every Wednesday to my chamber, and we have our stacks of petitions for review, and we vote on them. So I'm the scribe. I open the book, I call the first petition for review, and we speak in order of seniority. We vote in order of seniority. So Justice Kennard casts her vote. And these aren't just yes, no, grant, deny. They always come with a discussion about the underlying case and whether we should or shouldn't grant review. We go around the table. If I get 4 grants, then we grant review. And if we grant review, then we let the parties know when the briefing is due and what the issue is that we granted review on. Once we grant review, the matter comes to the chief, and I assign the case according to caseload, according to history, according to interest, all the while trying to make sure that all the justices get about the same caseload so that it's an even distribution of cases. The Supreme Court typically hears and writes opinions on 110 cases a year. Last year, with my being new and not having Justice Liu yet, we turned out 85 cases, which is pretty good considering we were an incomplete court and a new court. So once I assign it to myself, I will then assign it to one of my attorneys, and we will work on a memo that is to distribute to the court. Say I get a memo in a civil case, I think that it's now time to go out to the court. It comes out with a tentative, affirm, tentative reverse, tentative new rule. It circulates simultaneously to all the other 6 justices. They read it, and then they send back with their preliminary responses. We call it a PR. What's your preliminary response? Up, down, yes, no, disagree, doubt, concur. And then I collect as the author all of those responses, and I look at them, and I say, okay, what do I have to change in my memo to get everybody's opinions and concerns answered? And if I can accommodate their concerns, I will write them into the memo. And I'll send out another memo that says, okay, thank you everyone for weighing in. This is what I'm going to do. And once we get 4 concurs, we set it for oral argument. We hear oral argument en banc, all 7 of us sit, and we all have now everything about that case. We listen to the attorneys, and then that very day, the same, if you argued in the morning, at lunchtime, we argue about your case in conference in my chamber. We all come back at lunch after the morning session. We talk about every single case, again the same way. Only this time, the author presents the case. If there's a dissent, the dissent speaks to their objection. And then we vote. We go around again. I start with Justice Kennard. What's your view on this case? Has it changed? And we go around the table, and everyone offers helpful hints from argument, what should be included, what shouldn't be included. And then the author takes all of those notes and all of the opinions so far, the preliminary responses, and tries to craft an opinion within 90 days. Because once the case is argued and it's submitted, we have 90 days to file the case for the public to review. So that's basically the process in a nutshell. I left out all the angst and hair tearing that we have ongoing on a regular basis.
We have time for one more quick question, and then so there's one in the back, and it has to be quick.
Yeah, Oliver Wendell Holmes, Justice, said that taxes are something we pay for civilization. And we keep talking about how there's no money for the courts. Courts are closing at 2 o'clock. There's no money for the filing system. There's no access to justice. The filing fees are going up. People don't have access to education. You go around to places in the state, you talk about how we were blocked from even voting for more taxes by representatives of certain areas, and that there, we have a system where you have to draw the connection between people have to vote for taxes in order to have access to justice or education. And do you draw that connection? That the representatives blocked us even from voting on it?
Well, I'll tell you, when I go around the state, I don't often comment on the other two branches of government in terms of the difficulties they face and the negotiations that must occur in those two entities. I realize that we all have different views of how the other branch operates. And we are very symbiotic. I mean, that's our nature of our checks and balances. And for me, I've learned in this year, it does little good to, for me anyway, to vilify or to cast blame or to complain. I'm in the solution. So when I talk to people who only want to complain to me, I'm very polite, but it's not my focus. I need to hear and move forward. And generally, blame has not been helpful in that. And I have to say very sadly that the judicial branch has engaged in a lot of blame itself. And not even on the other branch, but on ourselves. And I think that that's the worst possible trial strategy ever.
Well, I think it's time to wrap up. You've been wonderful. Thank you so much for your time.